A 9-0 decision. Every single justice. No dissent, no debate, no close call. When the Supreme Court agrees unanimously on anything in today's political climate, you stop what you're doing and you pay attention. Because unanimous decisions don't happen by accident. They happen when something is so legally clear, so fundamentally important, that even justices who disagree on almost everything else look at each other and say, yeah, this one's obvious. And this ruling directly affects you if you carry a firearm in your vehicle. Which means if you're watching this right now, the next few minutes could be the most important legal education you get all year. I'm going to break down exactly what the court decided, what it means for you at a traffic stop, what police can and cannot do now, and the specific mistakes gun owners make that turn a routine stop into a federal nightmare, even after a ruling like this. Let's get into it. The Supreme Court of the United States just issued a ruling that legal firearm ownership in your vehicle cannot, by itself, serve as justification for a warrantless vehicle search. Read that again. Legal firearm ownership cannot, by itself, justify. A. Warrantless. Search, 9 justices, 0 disagreement. Now, if you're thinking, well, that seems obvious. Of course they can't search your car just because you have a legal gun hold. That thought. Because what makes this ruling so significant isn't just what it says. It's the fact that it had to be said at all. It's the fact that lower courts across this country were getting this wrong, consistently, repeatedly, in ways that were stripping law-abiding gun owners of their constitutional protections one traffic stop at a time. That's the part that should concern you, not just what the Supreme Court ruled, but why they had to rule it in the first place. Here's what was happening. Over the past several years, a pattern emerged in traffic stop cases across multiple states. Officers would pull someone over for a minor infraction. A busted taillight, a rolling stop, slightly tinted windows. During the stop, the driver would do the right thing. They would inform the officer they had a legally owned firearm in the vehicle. Maybe they had a concealed carry permit, maybe it was stored properly in the glove box, maybe they volunteered the information because they wanted the interaction to go smoothly. And here's what happened next. In too many of these cases, the officer would use the presence of that legal firearm as the justification to conduct a full vehicle search. Not a safety check, not a pat-down, a full search. Glove box, center console, trunk, everything. Lower courts in several jurisdictions upheld these searches. Their reasoning went something like this. A firearm in a vehicle creates a safety concern for the officer. That safety concern gives the officer reasonable suspicion to investigate further. Investigating further means searching the vehicle. On the surface, that might sound logical, but think about what it actually means in practice. It means that exercising your Second Amendment right automatically costs you your Fourth Amendment right. It means that doing something completely legal owning a firearm puts you in a worse legal position than someone who isn't exercising a constitutional right at all. It means the more law-abiding you are, the more exposure you have. That is constitutionally backwards. And that's exactly what the Supreme Court just said. Before we go any further, let's make sure we're all on the same page about what the Fourth Amendment actually says and does. Because a lot of people think they understand it, and they don't. The Fourth Amendment protects you against unreasonable searches and seizures by the government. In practical terms, it means police generally need either a warrant signed by a judge or what's called probable cause before they can search your property. Probable cause is a specific legal standard. It doesn't mean the officer has a hunch. It doesn't mean they think something might be wrong. Probable cause means there is specific, articulable evidence, real evidence, that a crime is being committed or that evidence of a crime will be found. Not suspicion, not possibility, evidence. There's also a lower standard called reasonable suspicion, which allows officers to briefly detain you and conduct a limited pat-down for weapons if they can point to specific facts suggesting criminal activity. But even reasonable suspicion requires more than a hunch. It requires facts. Here's where it gets complicated for vehicle searches specifically. Courts have long recognized what's called the automobile exception to the Fourth Amendment. Because vehicles are mobile, courts decided long ago that police don't always need a warrant to search a car the way they would to search your home. But, and this is critical, the automobile exception still requires probable cause. It removes the warrant requirement. It does not remove the probable cause requirement. What some lower courts were doing was stretching that automobile exception so wide, it was essentially swallowing the rule. They were saying the presence of a firearm equals a safety concern. A safety concern equals probable cause, and probable cause triggers the automobile exception. Search the car. The Supreme Court just collapsed that entire chain of reasoning. Because step 1 is wrong. The presence of a legal firearm is not evidence of a crime. Owning a gun is not a crime. You cannot manufacture probable cause out of constitutionally protected activity. And without that first domino, the whole thing falls apart. Now, let me walk you through the actual fact pattern that brought this to the Supreme Court. Because understanding what happened in this specific case is going to help you understand exactly where the line is drawn. A man was pulled over in a routine traffic stop. Minor violation, nothing serious. During the stop, the officer asked him to step out of the vehicle, which is perfectly legal. Officers have the right to ask you to exit your car during a traffic stop. That's established in existing precedent, and it is not being changed by this ruling. The driver stepped out, cooperated, was respectful. When the officer asked if there was anything in the vehicle the officer should know about, the driver was honest. He said yes, there's a legally owned firearm in the glove compartment. He had documentation, he had a valid permit, he did everything right. The officer then conducted a full vehicle search. His stated justification was that the presence of the firearm created a safety concern that warranted the search. During that search, the officer found ammunition that technically violated a local ordinance, an obscure local regulation the driver wasn't even aware of. The driver was arrested and charged. The driver fought it. Lower courts sided with the officer. The case moved up through the system. And ultimately, the Supreme Court took it and issued that 9-0 ruling. Here's what the court said in plain language. The driver did nothing wrong by having a legal firearm. He did nothing wrong by disclosing it. His honesty and his legal gun ownership cannot be combined to create justification for a search that wouldn't otherwise be justified. The search was unconstitutional. The arrest that resulted from it was built on an unconstitutional foundation. That's the ruling. That's what it means. And here's why it matters so much for what happens to you the next time you get pulled over. The court sent a message that everyone needs to hear. Your constitutional rights are not in competition with each other. The Second Amendment and the Fourth Amendment don't cancel each other out. They coexist. They reinforce each other. The government cannot use your exercise of one constitutional right as grounds to strip you of another. You don't have to choose which right to protect. You're entitled to all of them simultaneously. That principle came from every single justice on the court. Everyone covering this story is focused on the headline. 9-0. Big win for gun owners. But the part nobody's really digging into is what this ruling reveals about how widespread the problem was in the first place. For this case to reach the Supreme Court, the lower courts had to get it wrong first. And they did. Multiple courts in multiple jurisdictions looked at this situation, a legal gun owner being honest with a police officer, and decided that his constitutional rights were subordinate to an officer's generalized safety concern. Think about how many traffic stops happened between the time those lower court decisions came down and right now. Think about how many law-abiding gun owners had their vehicles searched under that flawed standard. Think about how many people were in the exact same position as the driver. In this case, doing everything right, being cooperative, having their legal firearm used against them, but didn't have the resources or the persistence to fight it all the way to the Supreme Court. Those people lost their Fourth Amendment rights without anyone ever telling them it was wrong. That's why this ruling matters beyond just the legal precedent. It's an acknowledgement that the system was broken in a specific way that was specifically hurting law-abiding gun owners. And it took 9 Supreme Court justices to fix it. Now, here's the practical reality going forward, and this is where you need to pay very close attention. This ruling is a massive win, but it does not make you untouchable during a traffic stop. It does not eliminate police search authority. It does not mean that having a legal gun is a magic shield that prevents all problems. Officers can still ask you to exit the vehicle. That right was established before this ruling, and nothing about this decision changes it. Officers can still temporarily secure the firearm if there are specific, articulable safety concerns during a stop. And the key word is specific, not just a generalized, there's a gun in there. They can still search if they have actual probable cause based on evidence of actual criminal activity. If the officer smells marijuana, if they see drug paraphernalia in plain view, if you match the description of a suspect in a nearby crime, those create probable cause independent of your firearm. Officers can still verify your permit and ownership documentation, and they can still search with your consent, which brings us to the single most important thing you need to understand about this ruling. If you say yes when the officer asks if he can search your vehicle, you have just waived your Fourth Amendment protection. This ruling means nothing if you consent to the search. We'll come back to this. What police cannot do, what this ruling explicitly forbids, is treat the presence of a legal firearm as sufficient justification by itself to conduct a warrantless search. That is the line. Legal gun plus nothing else equals no search authority. Now, Let me walk you through the specific scenarios where things can still go wrong, even with this ruling on the books. Because this is where most people get overconfident, and that overconfidence becomes dangerous. And I want to be very honest with you about something. I've seen people walk into legal trouble not because they were bad people, not because they were careless about the law, but because they assumed a win in the courts automatically translated into protection on the street. It doesn't work that way. Knowing the ruling exists is step one. Knowing exactly where it applies and where it doesn't is what actually keeps you out of trouble. If you're in a state with complex permit reciprocity laws and you didn't verify that your home state permit is recognized in the state you're driving through, the officer may have legitimate uncertainty about whether your carry is even legal. This ruling protects legal gun ownership. If there's genuine uncertainty about legality, that uncertainty itself can shift the analysis. If the officer sees the firearm before you disclose it, say it's in a holster on your hip and you forgot it was there when you rolled down the window, the officer's observation of an unsecured or visible weapon interacts differently with state law, depending on where you are. Know your state's rules on open carry and vehicle carry before you're ever in this situation. If there are other factors the officer can point to, driving at 2 a.m. in an area known for criminal activity, appearing evasive rather than just nervous, other items in plain view, courts use what they call a totality of circumstances analysis. One factor alone might not justify a search, but several factors together can add up to reasonable suspicion or even probable cause. Your legal firearm then becomes one piece of a larger picture rather than the sole justification. And here's something that might be uncomfortable to hear. Not every officer is going to be immediately updated on every Supreme Court ruling. Training takes time to implement. Some officers are going to push the boundaries regardless. If an officer searches your vehicle unconstitutionally, the remedy for that is in court with an attorney after the fact, not at the side of the road during the stop. This ruling gives you powerful legal ammunition after the fact. It does not give you the right to physically resist in the moment. So let's talk about exactly what you say and do, because knowing the law is one thing. Knowing what to actually say when you're sitting in your car with blue lights flashing in your mirror is something different entirely. Here is your step-by-step protocol. Memorize this before your next drive. The moment you pull over, control your hands and your environment immediately. If it's dark, turn on your interior dome light. Roll your window down halfway. Place both hands flat on the top of the steering wheel where the officer can see them the instant they step out of their vehicle. Do not reach for your registration. Do not reach for your wallet. Do not make any sudden movements. Give the officer complete peace of mind from the second they approach. Handle disclosure according to your state law. Some states legally require you to inform an officer that you are carrying a firearm. Other states do not. You need to know which category your state falls into before you are ever pulled over, not during the stop. If your state requires disclosure, do it calmly and clearly the moment the officer approaches. Say this: "Officer, I want to let you know I have a legally owned firearm in the vehicle. It's in the glove box. My permit is in my wallet. My hands are staying on the wheel and I'm waiting for your instructions." That's it. Simple, clear, non-threatening. You've disclosed, you've demonstrated awareness of safety, and you've put the ball in their court. Here's a statistic that should stop you cold. Studies on traffic stop encounters consistently show that the overwhelming majority of people consent to vehicle searches when asked by an officer, even when they have every legal right to refuse. Why? Because being asked by someone in uniform with a badge and a weapon feels like an order even when it isn't one. Because people instinctively feel that saying no makes them look guilty. Because in the moment, under pressure, with adrenaline running, most people default to compliance, even when compliance isn't legally required. That psychological dynamic is precisely why so many Fourth Amendment violations happen not through force, but through consent. The officer asks, the driver says yes, and just like that, the protection this ruling provides evaporates completely. If the conversation shifts toward a search request, this is where most people either freeze or make a critical mistake. They either say yes because they feel nervous, or they get aggressive and argumentative about their rights, which escalates the situation fast. Neither is the right move. The right move is calm, firm, and brief. If the officer asks to search your vehicle, your response is, "Officer, I respect your safety and I'm fully cooperating with you, but I do not consent to any searches of my vehicle." That's it. 5 clear words embedded in a sentence that stays respectful. You don't argue. You don't cite case law at the window. You don't give a speech. You state your position once, clearly, and then you stop talking. If they search anyway, do not physically resist under any circumstances. I cannot stress this enough. If an officer conducts a search after you've declined consent, you do not touch the officer, you do not block their path, you do not physically interfere in any way. What you do is say out loud, clearly, for the record, I want to make it clear that I do not consent to this search. Say it once, clearly, then be quiet. That statement creates a legal record. Combined with this Supreme Court ruling, it gives your attorney exactly what they need to fight the search afterward. Physical resistance, on the other hand, turns a constitutional violation into an immediate arrest, and potentially something far worse. Document everything the moment the stop is over. Badge number. Officer's name if you caught it. Patrol car number. Time and location of the stop. Every word the officer said that you can remember. Every word you said. Write it down, or record a voice memo within minutes of driving away. Memory degrades fast. Details matter in court. And if your rights were violated, those details are the foundation your attorney builds on. If you're arrested or charged with anything, contact an attorney before you say another word to anyone. Do not try to explain your way out of it at the station. Do not assume that being cooperative in the moment will protect you. It might, but the safest move is always to ask for an attorney and wait. This ruling gives your attorney powerful tools, but your attorney needs clean, preserved facts to work with. Don't muddy the water before they get there. Now, let's zoom out and talk about why this ruling is bigger than just one case. Supreme Court decisions don't just resolve one dispute. They set precedent that ripples through every court in the country for decades. Lower courts are now bound by this ruling. That means every judge in every state who handles a suppression motion, a motion to throw out evidence because it was obtained through an illegal search, has to contend with what the Supreme Court just said. If the only justification for a search was a legal firearm, that evidence should be suppressed. The case potentially falls apart entirely. That is a massive shift in how these cases get litigated across the country. Law enforcement agencies are going to need to update their training and policies. For years, some officers were taught that a firearm in a vehicle during a traffic stop automatically elevated the situation and justified a more invasive response. That training was based on the lower court rulings that the Supreme Court just overturned. Departments that don't update their procedures are now exposing themselves to civil liability every time an officer conducts a search justified solely by a legal firearm. Here's the thing that actually concerns me most about where things go from here. Most people are going to hear 9-0, gun owners win, and assume the problem is solved. It isn't. Yes, this is now the law of the land, but human beings are running the system. There will still be officers who push the boundaries. There will still be complicated fact patterns where the lines aren't clean. There will still be state and local laws that create specific complications this federal ruling doesn't fully address. Think about this practically. If you're a gun owner who regularly drives, you may cross state lines without giving it much thought. You probably know your home state's laws reasonably well. But do you know the vehicle carry laws for every state on your regular routes? Do you know whether your permit is recognized? Do you know whether your firearm needs to be unloaded and locked in a separate container for transport? Do you know which states require immediate disclosure versus which states leave it to your discretion? These are not hypothetical edge cases. These are the exact scenarios where law-abiding gun owners find themselves facing criminal charges despite doing nothing they believed was wrong. Right now, multiple state legislatures are pushing new boundaries around concealed carry reciprocity across state lines. Several states have recently altered their vehicle transit firearm statutes in ways that could accidentally turn a routine road trip into a criminal violation if you cross the wrong border without knowing the rules. A Supreme Court ruling about warrantless searches does not protect you from a state law you didn't know existed. That's the ultimate reality check. The law as it exists on paper and the law as it's applied in practice can be two very different things. Your rights are only as real as your awareness of them and your ability to assert them at the right moment in the right way. A unanimous Supreme Court ruling doesn't fix what happens at the side of a dark road at 11 p.m. when it's just you and an officer and no witnesses. What fixes that is knowledge. Your knowledge of your rights. Your knowledge of this specific ruling. Your ability to stay calm, say the right things, and preserve your legal options. And afterward, your attorney's knowledge of the precedent that backs up your argument. The gun owners who end up in the worst situations are almost never the people who were intentionally breaking the law. They're the people who were caught off guard. They didn't know what they could and couldn't say. They didn't know what to consent to and what to refuse. They didn't know that 5 words, "I do not consent to searches," could be the difference between a bad night and a federal charge. So let's bring everything together with complete clarity. The Supreme Court ruled 9-0 that legal gun ownership in your vehicle cannot by itself serve as justification for a warrantless vehicle search. Your Second Amendment rights and your Fourth Amendment rights coexist. They are not in competition. Exercising one does not cost you the other. Police can still ask you to exit the vehicle. Police can still conduct searches if they have actual probable cause based on evidence of actual criminal activity that goes beyond the firearm itself. Police can still search with your consent, so do not give it unless you have a deliberate reason to. Police can still enforce state and local gun laws, which means you need to know yours before you're ever in that situation. What police cannot do is point to your legal firearm as the sole justification for a search. That argument is now dead at the Supreme Court level. Your moves at the stop? Dome light on if it's dark, hands visible on the wheel at all times, know your state's disclosure law and follow it, decline consent to searches calmly and clearly with, I do not consent to any searches, never physically resist even if a search is unconstitutional, document every detail the moment you drive away, and contact an attorney before you say another word if you're arrested or charged. This ruling is a genuine, significant win. It is a clear and unambiguous statement from the highest court in the land, agreed upon by every justice without exception, that gun owners do not forfeit their privacy rights simply by exercising their gun rights. Understand it, internalize it, and then stay sharp because the law keeps moving. And one ruling, even a unanimous one, does not solve every problem you might face the next time those red and blue lights appear in your rearview mirror. Stay informed, stay prepared, and stay legal.